Good morning, everyone, and welcome to this edition of the Senate Commerce and Labor Committee for the 81st Legislative Session. Madam Secretary, please call the roll.
Senator Hardy? Here. Senator Lang? Here. Senator Neal? Senator Pickard? Here. Senator Scheibel? Here. Senator Settlemeyer? Chair Spearman.
Thank you. Here. And Senator Settlemeyer will be late, and that's the main reason we'll be doing a work session later. I never like to do a work session without all the committee members. So he'll be late coming in, and we will do the work session a little bit later. Today we're going to have a hearing on Assembly Bill 391 and work session on 227. Just a reminder that the legislative building is partially open, providing that you go through some other requirements to get into the building, but you can still participate. You can register to participate on Nellis. You can submit written comment. You can share your opinion via Nellis, or you can view committee meetings on online or on YouTube. Just a note that while meeting registration is required to participate, it does not guarantee that you will be able to speak. That's one of the reasons I ask people, if someone has already said what you'd like to say, the gist of what you'd like to say, then ditto is a good response, and that allows more people to have an opportunity to speak. When you're on the phone line, please pay attention, please pay attention, please pay attention to the bill that we're on and the segment that we're on. Staff will call you by the last 3 digits of your phone number. If you need assistance with any of these things, then you may feel free to contact our committee staff at the email listed on the agenda. All exhibits must be in by 8 o'clock the day before so that they may be uploaded to Nellis. In addition, any person proposing an amendment to a bill to be heard by this committee must first talk to the sponsor, because I will not accept any amendments unless the sponsor is aware of that amendment. And all amendments that are proposed must be submitted 24 hours in advance. When testifying, please unmute your microphone and clearly state your name and project your voice. This ensures that those who are watching, especially those watching remotely, can hear and understand what you're saying. Pursuant to Nevada Revised Statute NRS 218E.085, it is unlawful for a person to knowingly misrepresent facts when testifying before a legislative committee, and a person who knowingly does so is guilty of a misdemeanor. The chair or any member of this committee may request a testifier to submit documentation supporting their testimony. Committee members, if you are virtual and have a question, please make sure you raise your hand through the Zoom application. And for those of you who are here, if you just raise your hand, I'll look to the left, look to the right, or our trusty policy analyst will also let me know that we have a question. And I will be able to call on you just as soon as we acknowledge Senator Pickard, as he is always the leader in questioning. And I see our vice chair, so she'll be second. But they always have really good questions. So raise your hand, and we'll make sure that you have an opportunity to ask your question. We're approaching the second House committee passage deadline, which is May the 14th. So I urge all those who have presented a bill in this committee to finalize any amendments as soon as possible. If we've not been able to work session your bill, then your bill will not make it out of the legislature this session. And finally, please put all your electronic devices, especially your cell phones and your laptops, anything that you could, sounds like you can make a pie with, an Apple, a BlackBerry, anything like that, make sure that you put those on mute so they don't disturb the proceedings. And so now let's open a hearing on Assembly Bill 391. We have Assemblywoman Anderson, Nina Laxalt, and Corinne Cedran. Did I pronounce that correct? Okay. Revises provisions relating to dispensing opticians. Please begin when you're ready.
Thank you, and good morning, Chair Spearman, Vice Chair Neal, and members of the Commerce and Labor Committee. My name is Natha Anderson, and it is my honor to represent Assembly District 30, which is Sparks and a little bit of Reno. I call it the heart of the Truckee Meadows. AB 391 includes some very, very extensive cleanup language from the Nevada Board of Dispensing Opticians to more closely reflect current practices of the profession, as well as clarify some of the more lengthy or cumbersome areas as it relates to NRS Chapter 637. In, I guess it was January, I was asked to bring forward a small cleanup bill. the word small was used more than a few times. And I was like, okay, sure, no problem, I can do that. And so imagine my surprise when I finally had a chance to meet with Nina Ms. Laxalt, as well as Ms. Sedrin, and it was the entire chapter. So it has been a adventure, to put it mildly. However, I believe the language that is being brought forward has done exactly what the board had planned to do, which was to take away some of the barriers from people in understanding how exactly to become a licensed optician. And then also making sure that people that transfer from other states, as well as even from other nations, are able to do so in a consistent fashion. There was some cleanup about the requirements, about the penalties, about the licensing fees. And to help with the numerous areas of cleanup, there's a very straightforward SB 391 Revision 1 breakdown, which Ms. Laxalt had created, which should be on Nellis. And if you have not received that, I can send that to you, which is much easier to follow along. Madam Chair, would you like me to walk through the whole breakdown or just go over the highlights or more cumbersome areas?
Now, why don't we just go over the highlights? I think most of the committee members have probably read the bill by now.
Great.
Okay?
Thank you. So the first more problematic area, or just to highlight, would be Section 6. Section 6 is one of the biggies where the requirements are very consistent, when before they had been all over the place, and then also makes it very clear what the waiver should be for those already licensed in other states. Section 9 is consolidating the fees all in one section. Before, they had been peppered, or I guess sprinkled. Wow, I seem to be using a lot of food metaphors, sorry, throughout the chapter. None of the fees are new. These are all simply put into one consistent spot. Section 13, for those of you that received an email last week, this has been a huge concern over the last few days, probably last week. So I know that you all had a very extensive meeting last week that was, 2.5 hours long? For us, that was actually very helpful because it gave time for Ms. Laxalt, as well as the board, to meet with those voicing those concerns and to come up with an agreement. So we are actually reverting back to the language as it is currently in statute. There had been some possible changes that were made. However, based upon these discussions, we are simply going back to what the language is currently. Section 14 allows the governor to choose to fill a vacated committee seat to complete a remainder of a term. The reasoning behind that is the word may is there because if there's only 2 more months left on somebody's term, why take the time to try to fill it? If, however, there is a year left, you need to fill it. But this gives the governor a little bit more leeway as to how long to take to fill those terms. Section 18, the board is no longer administering the test and has not been for some time. Instead, those exams are now performed by the national organization, the American Board of Opticians. I also have 2 individuals who, in case of questions, Corinne Sedrin, the Executive Director for the Nevada Board of Dispensing Opticians, and Nina Laxalt, my phone a friend right next to me, who's the lobbyist for the Nevada Board of Dispensing Opticians. I believe the president of the board will also be calling in. However, I don't believe she's part of this presentation. That's basically the information. I'm more than happy to have questions from Senator Pickard, Senator Neal, and other members of the committee as well. Looking forward to our conversation. Thank you.
Thank you. Right on cue. And Assemblywoman, you said that it was a long discussion last week?
That's correct. If 2.5 hours?
Yeah. Yeah, as I understand, some people had just gotten their driver's license, and next week they'll be able to apply for Social Security. That's how long it was. Senator Pickard.
Please don't let this one be that long.
Thank you, Madam Chair. Happy to oblige. And I appreciate the time you took with me before the hearing, so we'll keep this one short. The one question that I didn't think to ask before has to do with accepting gifts, grants, and donations. I'm looking at Section 17. Can you explain why we're doing that? I mean, I can imagine things, but maybe you can enlighten us a little bit.
Thank you. For the record, Nina Laxalt, representing the Board of Dispensing Opticians. That's actually language that was moved from another section, and if you go through boards, statutes throughout. Many and most of them have them. And I think the purpose of that is really, I don't know or if it's ever been used or why it was initially put in, but I believe that might be really more for grants, and I can have Corinne answer that more specifically if she could.
Hi, this is Corinne Sedgren. I'm the Executive Director for the Board of Opticians.
Can you do
so
me a
yeah,
favor,
just
get a little bit
clarify
closer
this
to your
one.
mic? Can you get a little closer to your mic, please?
Yeah. Is that any better? If I just talk a little bit louder? Can you hear me?
Yes, yes, yes.
Okay, I'll do my best to just speak a little bit louder. But yes, this provision was originally included in our provisions covering complaints and investigations. And the provision actually said that we could accept grants and donations to carry out investigations, which seemed to be a bit of a conflict of interest. Our investigations are supposed to be confidential until the board decides to take disciplinary action. So we decided to move this and make it just a general provision to allow the board to accept grants and donations to carry out its business. To my knowledge, the board has never utilized this provision, but it is pretty standard boilerplate from all of the for all of the other board occupational licensing statutes as well. And the reason we would request to keep this in here is because we do operate on such a tight budget. We are a very small board. We do have reserves, but in a case like we had last year, it was just unexpected. We had the COVID. We could have potentially, had reduced licensing fees, and we are operating on a small margin, so that would allow the board to continue to function in case of something unexpected. Thank you.
All right, thank you. I appreciate that. And I wasn't aware that you could, in the prior iteration, you could receive grants and gifts as part of an investigation, particularly if it's by the investigated. I think that would raise some eyebrows, so I appreciate that. And I'm assuming that's in the regs and that will be taken out in a future iteration of the regulations, or was that somewhere in statute? And does this bill remove it from there?
Corinne Sedgren, again, Executive Director. So this is currently in the statute, not in the regulation. So we would potentially clarify it in the regulations, although I don't know if it needs clarification, but it was originally here in the statute.
All right, I'll look for that. And then the other question was in section 13, where we're removing verification of lenses and frames. This is something that I was under the impression that opticians did regularly. Is there a reason why we're deleting verification? Is that just to allow others who are doing other things? I know my ophthalmologist, for example, will verify it, but he's licensed to do this work. So why is this being removed?
Thank you, Senator Pickard, Assemblymember Anderson, for the record. I'm actually going to have Ms. Laxalt answer that momentarily. However, this was the item that was of numerous conversations, and so I'm going to have Ms. Laxalt go into that a little bit deeper.
For the record, Nina Laxalt. Senator, Section 13, and I've just looked at it on my breakdown here on the amendment, and I failed to mention the actual section, but on your proposed amendment, it's the third portion of the amendment, and that actually is Section 13. And because we had a little controversy with another group, what we decided to do was to remove all changes, any and all changes to that section of the bill, and to revert it back to its current statute so that the parties could work together in the interim possibly through the regulatory process.
All right, I appreciate that. And not to maybe pull off a scab, but can you tell me what the disagreement was about and why this was an issue?
I can try, and I don't want to speak for anybody else, but it had to do with the process, Nina Laxalt for the record, it had to do with the process between when a prescription is written to the endpoint of delivery. And I believe the main concern was that when a corporation sends glasses out, by Nevada law, they are supposed to be reviewed by a dispensing optician prior to going out to a customer. The discussion was around if the customer is outside of the state of Nevada, there shouldn't have to be that last final inspection, and the board disagreed with that. So we'll keep working with that party.
All right, I appreciate that. And thank you again for your time with me before the hearing.
Thank you, Vice Chair.
Thank you, Madam Chair. So I had a question on section 15, but it's slightly different. So getting into the tight budget and the margin that you guys operate off of. So how many investigations do you guys typically do in a year? Because if you have a tight margin, I mean, I get investigators, but lobbyists, professional consultants, and then attorneys. So I want to try to get into how often do you have to employ the attorneys, the costs that you're engaged in, because these aren't or statements, these are ands.
Thank you for the question, Senator Neal. I'm going to have the Executive Director, Miss, Cedrin. I
That's right,
just called her by
Cedrin.
her first name, answer that.
No problem. Hi, Corinne Cedrin here, Executive Director. So yes, this is just to allow the board to contract, and actually we already in the current statute have the ability to contract with professional consultants. We just kind of clarified the titles of those particular consultants. As it stands right now, our legal representation is provided by the Attorney General's office. So we're not hiring an outside attorney, but this would allow us to. Investigators is pretty routine. We don't have that many in-depth investigations per year. We investigate the complaints we receive. So I'd say probably a max of 5 to 6 investigations per year. But those can be a bit pricey. But as far as lobbyists, obviously we have a lobbyist with us here today. But that's pretty much restrained to years when there's a legislative session. Or when we are proposing a regulatory or statutory change. We do not have a full-time lobbyist on staff. So this is much more just permissive and to clarify the board's ability to hire these various, consultants and professionals, more so than stating that the board will hire these professionals.
Okay, thank you for that. And then my next question's on section 23. So this is the fines piece. Well, I have 2 questions in the section. So you have administrative fine of not more than 10,000, but it's based on a combination of, and it's each incident. And I guess what's not clear that this is an increase. There hasn't been anything placed in the record in terms of what's going on in the space where you now need to do this combination of fines and really go after individuals for violations. So can you put some issues that are in play where you need to, what's happening around the unprofessional conduct, et cetera?
Yes, this is Corinne Cedrin, Executive Director. If I may, could you just clarify which subsection under section 23?
So in section 23, that language is in section 2, sub 2 of the board fines after notice in a hearing. And then it has the up to 10,000. And then there's another provision, I think, later in the bill that talks about, I believe it's section 25, that also talks about the combination and each separate violation if you issue a citation. So there's two different sections. 23 and 25 speak to the fines or the combination thereof.
Right. So as Corinne Cedrin, section 23, I believe this is just an instance of us reordering the current provision provisions to make them a bit more organized and cohesive. We did not increase the fine here, the maximum fine. So each act constituting grounds for disciplinary action is it can be fined $10,000 under current statute. So in this case, these grounds, not only the grounds for disciplinary action, but the actions themselves are in current statute. We did not increase any of the disciplinary actions. We just combined the provisions here. And then with respect to section 25, we did remove that increase. We had tried to increase the cap of the fine from 1,000 to 10,000 with the rationalization that this fine pertains to an employer versus just an individual. And our thought process was that oftentimes the employer is the more culpable party when there's unlicensed activity taking place. So we were going to increase that fine to $10,000, but it should be on the current copy with the amendments that section 3, that $10,000 is struck through and it's put back to its original $1,000. And
So really quick, so
yes.
amendment, we're talking about the amendment that's uploaded on Nellis, right?
Correct. Nina, I'm sorry, Ms. Laxalt, maybe you could help
Yeah.
clarify on.
Do me a favor, state your name every time you speak, state your name, just for the secretary.
Thank you. Nina Laxalt for the record. No, the amendment was the amendment proposed on the assembly side where the section, and I think we're talking about two different sections. I think section 26 sub 3 was moved up to $10,000, and I believe we struck that and put that back to original 1,000. Subsection 3 of section 25 is, again, current language that wasn't changed at all.
So, Chair Spear, I'm super confused. I printed out the first reprint. So is there a second reprint? Because the first reprint that I printed, which would have had the adopted amendments from the assembly, my section still have $10,000. So is there another version out here that I don't have?
This is Corinne Sedgren, Executive Director. So under section 23, that fine is $10,000, and that's the way it is in the original statute. This fine pertains to an individual who is caught dispensing without a license. The instance where we were going to increase the fine was section 26, and that was with respect to employers as opposed to individuals. So this first section does say $10,000, and that's current. That's the current language, and the original statute just moved. The provisions just been moved. And then section 26 is where we struck through that $10,000 increase and put it back to $1,000.
Assemblymember Anderson, I just want to make sure as well that we're all discussing the same areas. So I'm also looking at the first reprint, page 18, section 25, line 15. It would be where you've got the 10,000. That is what's currently in statute, and I believe that's one thing that Senator Neal is asking about. But then on page 19, which is in section 26, on line 6, there's the $1,000. So I want to make sure that, is that the area you're asking questions about, Senator Neal? Just to make sure that we're in the right area of the first reprint.
Thank you. I was asking about section 25. Yes, I saw the 10,000, but the new language is for each separate violation. I didn't see that struck out, and I saw that as an increase. And so because it's for each separate violation. And then, because this is the admin fine piece. And so that I was asking questions on section 25. I didn't mention section 26.
I completely see now what you're saying, because before, I'm so sorry to the Secretary, Assemblymember Anderson. You are absolutely correct. There was a period after the 10,000 which has been removed, and now it does state as new language for each separate violation of the individual in section 25. And I think that's what you're asking questions about, if Ms. Cedric would like to clarify that as well. Am I understanding that correctly?
Yes, Assemblywoman Anderson, yes, because the way I read it, it was each separate violation, and then in sub 4, it says a combination of penalties set forth in subsections 1, 2, and 3. And so I saw it as an increase, because if you have not more than 10,000 for each separate violation, you could have a combination rolled in, which, let's say it's 5,000, 5,000, 5,000. That combination language is an increase. And so that's what I want a dialogue around. So thank you for the clarification, Assemblywoman.
And Assemblywoman Anderson, I will ask either the president of the board or the executive director of the board to be able to answer this, because again, this is their language and they have intimate knowledge of it as opposed to me. So if one of the other individuals would like to answer that and engage in that dialogue, that would be wonderful now that we have that clarified. Thank you.
I'll go ahead. This is Corinne Sedgren, Executive Director. So upon review, that is correct. There was initially a period there and then added for each separate violation. So if that's going to be considered an increase, I understand that. This is language that was supplied to us by the LCB and did not, we reviewed it as carefully as we possibly could, but as obviously we did not catch that this was actually a change to the language. And I think that on the part of the LCB, they were just trying to use boilerplate language that's, typical of what you see in these types of statutes. So to strike through that for each separate violation, that's not an issue for us, I don't think, because it's what it currently says in statute. That was not something we were intending to change. And then as far as the combination of the penalties that set forth, I can also see why that would be considered an increase if the current language just says or, but I don't believe it. I'm trying to review here and see, if we're currently able to assess all of those penalties together. So what it says now in our current statute is if the board determines that a person without a license is engaging in prohibited contact, may, after notice of an opportunity for a hearing, impose an administrative fine of not more than $10,000. And then it says we shall issue on the person in order to cease and desist. So this issuing of a citation, that is new, and that was something we did intend to add. The purpose of issuing a citation was to sort of bypass the huge expensive hearing that would normally take place. So this citation authority is an addition. However, that $10,000 fine, as well as notice to cease and desist, that's in current statute.
Madam Chair, if I could, Nina Laxalt for the record. And Madam Vice Chair, I think what we're all saying is, yes, you're correct. We did not catch that, and we can certainly add that to the amended language to remove for each separate violation.
Okay, thank you. Thank you, Madam Chair. I'm done.
Thank you, Harriet Mason. Good catch.
Oh my God. Cut it out.
Senator Hardy.
Thank you, Madam Chair. I've got two very basic questions. One is, where in the world did we get the 2/3 if everything stays the same? And second is, in some other boards, if you're not licensed, the licensing authority has no jurisdiction because you're not licensed. So this fine that is being done, is it a fine that's assessed by someplace elsewhere and not any jurisdiction of the board anyway, So how can we have the executive say anything because she has no jurisdiction over somebody who's not licensed?
Chair Spearman, Senator Hardy, if I could for a minute, Corinne.
Just go direct, go
Neil
direct.
Laxalt, thank you. I'm sorry, could you repeat your first question? It was an easy
2/3.
answer. Oh, the 2/3, we don't know. There's your answer. I've seen other things this session that perhaps, maybe they're erring on the side of caution, but this really just takes all the fees that were, when I first looked at this statute and was trying to explain it on the other side, it was like trying to unscramble an egg. And so one of the changes that the board wanted to make was putting all the fees in one location, which a lot of boards have, ... And that's all this does. And apparently that triggered a 2/3, but in fact, this bill should not raise any fees, fines, nothing. So that's a question for somebody else.
Well,
Your
I
sec-
agree with you.
Yeah, thank you. For the second question, several years ago, if you recall, there were many boards that were having problems with unlicensed practices. A lot of it was Botox and things like that. And I believe that started the trend of boards having the ability or getting the ability to be able to go after those that were unlicensed and practicing illegally. And I will let Corinne further define that as to when it came into the statute and how they go about processing and proceeding on that.
So I guess my question then is twofold then. Where does the money go? And who prosecutes them?
All right, Corinne Sedgwick, Executive Director. So I will clarify, this is not something new to the statute. This is currently in the statute, the board's ability to prosecute unlicensed activity. The board would be the one to issue the complaint. We would do a standard 233B notice of hearing if we found evidence of unlicensed activity, and we would impose the fine. We follow the Nevada law regarding collection of fines, which means they go to the state controller's office, and then we can collect our legal fees back out of those fines, but we don't keep the fines. But this is not new language here. This is currently within the board's jurisdiction to go after unlicensed activity. That's one of the board's primary roles. So I would not say that this is the same as the previous section we were discussing. This is not increasing the board's ability to penalize anybody. This is already there in the statute.
I guess it's even more basic than that. If you find somebody who is unlicensed, do you have a gun? Do you go in and say you're unlicensed and we're investigating? Or do you just have a complaint to the AG's office? Or where does it go? How do you investigate somebody safely?
Corinne Sedgwick, Executive Director. The same way most of the occupational licensing boards would, we use a private investigator who's licensed and insured. We don't just send somebody in, that doesn't know what they're doing. But typically, the initiation is a complaint that we receive complaining about unlicensed activity. If we have reason to believe the information of the complaint, we follow up with an investigation.
So you hire a private investigator, and that's in your budget?
Correct.
Thank you.
For a complaint. We hire on a case-by-case basis to investigate that particular complaint. We don't have a licensed investigator on staff.
Thank you. Thank you, Madam Chair.
Thank you. And I guess my question as a follow-up to Senator Hardy's would be, and the cost of the investigation would be, or do you have any idea?
This is Corinne Sedgwick, Executive Director. I can approximate, I would say A typical investigation can cost between $1,000 and $5,000, depending on how many times we have to send the investigator back to the location. And typically the most expensive part of the investigation is not even the hourly cost for the services. It's purchasing a set of eyeglasses or contact lenses, whatever we have to do to verify that unlicensed activity is taking place.
Thank you. Committee members, additional questions? Okay. Seeing none, is there anyone here in the room, I'm sorry, some woman, is this, okay. Anyone here in the room who is here to testify in support of Assembly Bill 391? Seeing none, broadcast, let's go to the phones. We'll do 20 minutes per segment and 3 minutes per individual.
Thank you, Chair. Good morning. If you would like to testify on AB 391, please press star 9 now to take your place in the queue. Again, if you would like to testify in support of AB 391, please press star 9 now. Chair, you have no callers in support at this time.
Let's go to opposition.
If you would like to testify in opposition of AB 391, please press star 9 now to take your place in the queue. Chair, you have no callers in opposition at this time.
Anyone neutral?
If you would like to testify neutral on AB 391, please press star 9 now to take your place in the queue. Chair, you have no callers neutral at this time.
Thank you. Senatorwoman, you have any closing remarks?
Thank you, Assemblywoman Anderson. Thank you again for this presentation, for the questions as well, for the clarifications. We will make sure to add in the concern that Senator Neal brought forward, because that was an oversight on our behalf of not seeing it. Thank you, though, and looking forward to having this work session soon. Thank you, Chair.
Thank you. A lot of that will be up to you all. Make sure you get the amendments cleared up, questions cleared up. Okay. Thank you. And so with that, we will close the hearing on Senate Bill 391. Senator Settlemyer is not here, so we're going to take about a 5-minute recess and see if he's on his way. For those of you who are new to the process, this typically happens around this time of the session because many of us are testifying in other committees, and sometimes there's more than one committee we're testifying in. So I always like to give the benefit of the doubt to the member because I know it's difficult to be in 3 different places. I'm expecting someone, a really smart government relations person, to come forward with a bill that authorizes cloning. And so if you can come forward with that, I have a really good piece of dark chocolate, okay? We're in recess for about 5 minutes. Thank you. All right, so thank you so much for your indulgence, and Senator Settlemeyer is here now, and we will do our work session on Assembly Bill 227. Mr. Megrejo?
Thank you, Madam Chair. Assembly Bill 227, for the record, Cesar Magrejo, Community Policy Analyst. Assembly Bill 227 revises provisions relating to contractors and is sponsored by Assemblywoman Carlton. It was heard on April 23rd, 2021. The bill provides that a contractor may personally perform work that requires a contractor's license or may perform the work by or through employees of the contractor or of another contractor. Additionally, those persons or a person employed by a private employment agency licensed by the Labor Commissioner may perform for a contractor work that does not require a contractor's license. The measure revises the list of acts that constitute cause for disciplinary action against a licensee by the State Contractors Board to include entering into an agreement with a natural person who is not an employee of the licensed contractor and not licensed as a contractor to perform for the licensed contractor any work that requires a contractor's license. In addition to the disciplinary action or other action that may be taken against the licensed contractor, such an agreement is void and unenforceable. And Senator Spearman proposes the following amendment, which is to revise Section 4 of the bill to make the bill effective upon passage and approval for the purpose of adopting regulations and engaging in any other preparatory administrative tasks, and effective on October 1, 2021 for all other purposes. Madam Chair, that's all the amendments.
Thank you. Committee members, any questions or comments? Vice Chair? Comments? No? And Senator Pickert?
Thank you, Madam Chair. I just want to get on the record. I had asked for backup from a comment that the Contractors Board made relative to their claim that they had pursued prior similar conduct. They sent us a link. In it were 6 decisions. There was the American Fire and Electric case, Summit Drywall and Paint, Hardy Companies, Kari, I don't know, K-A-H-R-E, don't know how to pronounce that, Rockus Consulting, and PKMM, Inc. And I think it's important to note that none of the cases, only one of the cases dealt with leasing companies. Employee leasing companies. The Summit Drywall, Hardy Companies, Kari, Rockas, and PKMM didn't deal with these types of cases at all. And I think it's really important to note that the one that did was an ALJ decision, an administrative law judge decision. For those who may not be aware, an ALJ is someone that is technically paid by the division, or in this case the board. They're independent. They hear appeals from the administrative decision. And in this decision, the ALJ made a very important comment that the board did not contest. He said that the wage-earning employees leased from properly registered leasing companies by licensed contractors are, in fact, the regular full-time employees of the licensed contractor. The employees are under the supervision and control of the licensed contractor. This ALJ does not see how the employee leasing model presented in this case conflicts with the legislature's mandate that the provisions of Chapter 624 are intended to promote public confidence and trust in the competence and integrity of licensees and protect the health, safety, and welfare of the public. So in the cases that the board used to support their position that the legacy case was improperly decided, and that supports their promotion of this bill, it's misleading. They did not cite any case that supports their position. And in fact, the one case that they did not challenge, which they could have done had they chosen to, they could have appealed the ALJ decision to the district court. They did not. They chose to accept it. They took exactly the opposite position. So I think the Contractors Board, I think that their representation to this committee was misleading at best, false if they knew about it. That is something I find deeply concerning because we rely on these people to tell us the truth and to support their decisions, and that's not what happened in this case. What is clear in my mind is that this is a practice that has gone on for better than 30 years without complaint and without any serious challenge to suggest that these licensed contractors, as the testimony provided, are largely minority and disabled or partially disabled contractors who cannot, for whatever reason, work a full-time position for a contractor. And the small businesses that rely on temporary labor who cannot afford to hire multiple people in order to move them from job site to job site are going to be put out of business. As a result, I cannot support this bill. I find that it is, well, it's offensive to me that the proponents of the bill would completely disregard the needs and the rights of those that have been working for 30 years in this space without so much as considering an amendment that I proposed that would resolve this for everyone without jeopardizing the public safety or their welfare. So I will be a strong no and urge this body or this committee not vote this bill out. Thank you.
Senator Settlemeyer?
Thank you, Madam Chair. I appreciate the opportunity to talk. Generally, we talk after we make the motion and the vote, but it seems we're talking now, so let's get it out of the way. I myself have used, through the local conservation district in Douglas County, private employment agencies. We found them to be extremely safe. Their individuals are well trained. They're very flexible on hours. So for weed crews and things that we've done agriculturally, when it spins up or down in the conservation district according to work, we've had this opportunity to work with them, and they've been working for a long-standing history, throughout the state of Nevada with these individuals. In that respect, both this bill specifically to contractors, and within that realm, the information we're looking at is we're looking at affecting 4,300 people's jobs at least. So 4,300 jobs are at stake to the contractors alone that generate over $16 million in wages. And I just can't see putting that many people out of work, and I will be opposing it. Thank you.
Thank you. Additional questions or comments? Okay. All right, so Madam Secretary, let's do a roll call vote. I'm sorry. I did it again. The spirit of Senator Ratty. I'm channeling Senator Ratty. Don't tell her I said that, okay? I would take a motion. Entertain a motion?
Amend and do pass.
Second.
Okay, so I have a motion from Senator Lang, amend to pass, and a second from Senator Scheibel. Yeah, okay. Second from Senator Scheibel. Additional questions or comments? Okay. Now, Madam Secretary, please call the roll.
Senator Hardy?
No.
Senator Lang?
Yes.
Senator Neal?
Yes.
Senator Pickard? No. Senator Scheibel?
Yes.
Senator Settlemeyer? No. Chair Spearman?
Yes. And let the record show that the motion does pass. And I'm going to ask Senator Scheibel, do you want to take this for a statement? Thank you. Okay, I think that's all the business that we have today. The button and the microphone are in a very odd place. It's hard to get to. So that's all the business we have for today, with the exception of public comment. So broadcast, do we have anyone on the phone lines?
Yes, Chair. If you would like to speak in public comment, please press *9 now to take your place in the queue. Chair, you have no one wishing to speak in public comment at this time.
Thank you. And with that, we will adjourn for today, and we will be back on tomorrow, Wednesday, at 9 o'clock for another edition of the Senate Committee on Commerce and Labor, with the 81st legislative session. With that, we are adjourned.